Welcome back to John's Briefs, everyone. We're here again with Mark Victor. This is scaring me, Mark. Man, the last two times we talked about, the bond phase and getting you out, and then the discovery phase. This last video we talked about the motions phase, and now I've already spent myself into the poorhouse, and I've already been punished like crazy with the process. We haven't even got to the trial yet. So let's talk to Mark, who has done this for 25 years. About the trial. Today's video is brought to us by the generosity of Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners. You win the fight, and they will help you win the fight after the fight for the rest of your life. There's a link in the description for a coupon code for a discount for all active self-protection watchers. All right, Mark, so we've already got the previous videos. We've gone through that. What's next?
Well, look, good criminal defense lawyers know something, and what we know is you really don't want to go to trial. Sometimes you have to go to trial, but who wants to be sitting there through a trial? It's one of the worst things that can happen to somebody. So there's always sort of a negotiations phase. I think this occurs, or ought to occur, after you've done all the discovery, after you've done the motions. And sometimes the motions can be used as sort of a negotiating point, because sometimes we'll file a motion. We may not know how it turns out. Well, it's pending. I'll go to the prosecutor and say, hey, look, if my motion gets granted, your case is going away. He'll say back to me, yeah, if your motion is denied, you're screwed. So maybe that's a good point.
Maybe that's a place that we come together and we say, what could we do?
That could be a good time to talk about it, right? And again, this is, to talk about this process and not to mention the reality of mandatory minimum sentences is to not do justice to the topic. Okay. So you have to understand, where we started in your first video, if people watched from the beginning, imagine I'm in a good shooting. Imagine you are in a good shooting. But the prosecutor, based on what maybe somebody else said, has some doubts about that.
Right.
If the consequences are you go to trial and the jury finds that you're not in a good shooting and you're going to do 20 years in prison.
It's a big deal. I mean, your life is over.
The prosecutor knows this. So the prosecutor says, here's a great deal for you. 3 months in jail and plead guilty and you're on your way with probation or something like that, some version of that. Even if you do feel like you did nothing wrong. I mean, put yourself in that position for a moment and put it in the context of your criminal defense lawyer. You come and you say, Mark, what are our real chances of winning at trial? I can tell you no reasonable, responsible criminal defense lawyer is going to give you better than 50%.
You don't know what a jury is going to say at any given time. You're taking a risk.
So think about that for a moment. You want to go to trial on a 50% chance. If you lose, it's 20 years. If you win, you walk.
Right.
Or here's a way out. Take a quick deal, a little bit of aggravation, and you're back to your life.
Well, I'd think in a case like this, especially if you go, hey, it's 3 months, he drops the felony, you don't lose your rights.
Well, even if he's not going to drop the felony.
All right, well, even if you've got the felony, you're like, oh my gosh, I'm going to lose my rights. This is terrible.
They want the felony for that reason.
Yeah. Yeah, well, and I know you've had clients that would just like, no, I'm not pleading guilty to nothing. I don't care. We're going to the trial. And because I'm going to stand my ground here legally.
I had one recently, just like that in a gun case. My guy pulled out a firearm and the neighbors were there and there was a dispute and we got, the deal got better and better and better. And I kept saying, look, man,
take the deal, dude.
I wouldn't take the risk. And he said, I did nothing wrong. I got a good team of lawyers. I'm going to trial. You know what happened?
Tell me.
They dismissed the case. So
at the end of things, he was right. And okay, it's a positive outcome, right?
Doesn't always go that direction.
But basically, that dude spun the roulette wheel and bet on black. And okay, you know what I mean? You won it, dude. I'm super happy.
I can tell you more often what I see in our appellate practice are people who rolled the dice and wish they hadn't.
Right. And now they're appealing, trying to find some way to get...
I had one not too long ago where they had a very, very short sentence, rolled the dice and wound up with 10 years. And the person said, my lawyer didn't really impress upon me the risk at trial. I didn't really I never thought I would actually get 10 years out of this. So you got to be very careful. And you know what I tell my clients? I say, look, you need 2 pieces of information. At the end of the day, this is why you hire a criminal defense lawyer, because you need 2 things told to you, and you need confidence in those 2 things. Number 1, what are your real shot at trial? What are you looking at if you go to trial? What evidence is coming in? What's not coming in? What are you looking at? Now, because I'm never going to give you better than 50%.
I mean, the prosecutor's probably not going to move forward with a case they don't think they can win.
Of course not.
I mean,
If
they're going to
moving-
dismiss charges early if they go, yeah, I can't win this case, so I'm not even going to try.
No question. They are moving forward on cases they think they can win. That is the standard. Normally, many of their offices will say, if we don't have a reasonable likelihood of conviction, we're not taking the case. And by that time, it's been screened in the probable cause.
Right.
It's been screened, well, we've done discovery, we've negotiated, we've pushed all the weak points of the case, and they still say, nope, we're still going to trial.
Right.
So, but imagine if I pulled you aside and I said, look, John, you're a buddy of mine. I think you got 90% chance of winning this thing at trial.
You're still talking a decade of 2 decades of life here.
10% chance of serving 20 years. Or take a quick deal where you lose your firearms, your right to keep and bear arms, let's just say for the rest of your life.
Yeah.
You're still going to take that deal, even at a 90% chance.
Yeah, you go a couple months and I can get back to my life and I can do the things that I need to do, you know. And I think that sucks personally.
It does.
It's you know, you're in this like you know, terrible, you're sailing between the you know, Scylla and Charybdis. Oh, there was an obscure Greek mythology reference. Rock in a hard place, right? And like, what am I going to do in this instance? But you go, man, a 10% chance at 20 years or a couple of months now, and I deal with the other stuff, and maybe in 5 years I appeal and try to get my, you know, rights restored or whatever.
So the two pieces of information you need to make a rational decision here. Number one, what are your real chances at trial? What's the landscape actually look like? Who's testifying? What are they going to say? How's it going to come out? What evidence are they going to see? You need to understand a good, clear picture on what the trial looks like. And then number two, what's the very best plea I can ever get in this case?
Right.
If you got doubts about either one of those two things, then you got a problem with your lawyer, right? Because if the lawyer lays out the landscape for you at trial and you say, I totally understand, I see what it looks like at trial, and then you feel comfortable and confident that when the lawyer says, this is the best plea we're ever going to get on the case, you turn it down, you're going to trial. There ain't no better pleas coming.
Right. There's nothing more. These are our options.
Then what you do is you compare those two things.
Right.
And
Because at the end of the day, you're still in charge of what's happening here. You're the one pleading or not.
that is absolutely true. The client gets to decide to plead guilty or not guilty. The client gets to decide whether to take the plea or go to trial. Always 100%. The client gets to do the time. The client gets to make the decision. But I can tell you this. What I tell people is you absolutely get to decide, but I'm going to keep talking to you till you make the decision I think you should make.
Sure. I mean, a lawyer at the end, you're a salesman, right?
I'm not going to let you do something stupid. I care too much about my clients. If they say, Mark, I think I want to go to trial, and I think that's a ridiculous decision, I'm going to say, well, let's talk about it some more. We'll go through it. If they say, I want to take the plea, and the plea's not so great, and we got great things at trial, you know, I might say, hey, you know, should really think about this. But usually the situation is, I felt like I did nothing wrong. I shouldn't have to plead guilty. I recognize I'm looking at a heck of a lot of time, and here's a plea that I'm not comfortable with, but I can live with.
Right.
That's usually the situation. I've stood next to many people who would have preferred to have gone to trial, and I would have loved to have taken their case to trial, but the risk is too high.
Right. Well, and I know, I don't want to derail this discussion, but I know in many places an Olford plea is kind of like what this is, right? But we can't do that here in Maricopa County.
Well, it's an interesting point. And so this comes out of a case, Alford versus North Carolina. And the concept here, and I think it's interesting to note this, and I think the Supreme Court made the right decision. What they're actually saying is, look, not everybody pleads guilty because they think they're actually guilty.
Right.
Some people plead guilty because they still think they're innocent, but they recognize there's some risks at trial, and they recognize that the plea provides them some benefits, and for that reason, they want to take the plea. Now, as a matter of policy, the Maricopa County Attorney, and we have a new one now who may have a new policy, will say, we're not going to offer you a plea, we're not going to let you plead to Alford, because if you're not willing to come in and say, I'm actually guilty, we're not going to accept your plea. To me, this is a bit short-sighted.
It is.
Because the world is filled with a lot of people who say, I really think I'm not guilty. And imagine, especially when you're dealing with self-defense, right? It's a question, always the question, what's reasonable? You might think it's reasonable. Maybe half the people who look at it think it's reasonable. Maybe half the people think it's there is no real standard of reasonableness. So you may have a difference of opinion. And so you might actually have in your head, I think what I did was reasonable self-defense, but because the guy died, I'm looking at 25 or more years, and I'm not taking that risk. I'm gonna take the deal. Now, this could be fixed, in my opinion, if we got rid of mandatory minimum sentences, which we really need to do. Because, and I got to say this, mandatory minimum sentences are depriving our fellow brother and sister human beings of jury trials.
Yeah, because of the mandatory minimum, they'll take deals that they never would take otherwise.
Yes, and I think that the way to fix this is to give the judge, the sentencing judge, more discretion. Let me give you an example of what I'm talking about. You know, you might see in the newspaper, a man convicted of murder gets probation. That would be an outrage.
Sure.
But maybe it shouldn't.
But yeah, maybe there could be a time where you're like, no, he did murder somebody, but there's all these mitigating circumstances or whatever.
We could imagine a situation that's close, right? There's so many different variations of okay, I'm at home, it's late at night, I'm in bed, I'm sleeping, I hear a noise, I get up, I take my gun. Many versions of this story.
Sure.
But imagine you've actually been drinking, which you're absolutely entitled to do. You're home and you're in bed and your judgment's a little messed up. Maybe you're 80 years old. Maybe there is a burglar in your house. Maybe really is a risk. But maybe when you pulled out your gun, he decided, I think I'll leave now. And he turns and you get him right just on the shoulder. Could that be a first-degree murder? Maybe. Might it be a good self-defense? Maybe. But if he decides to take the risk and he goes to trial and the jury says, we think it's a close call, but we're going to go with murder. Do you think it would be reasonable for a judge presiding over the trial who understands everything to say, look, here's an 80-year-old guy with no priors. He wasn't looking for trouble. The judgment was just a tad off. Do we need to put this guy away for 25 years? We could put him on probation and he'll be just fine.
Right.
That should be the right sentence. But because we're in a soundbite society where people don't care to look beyond the headline, I think that, and the same is true on the other side, where the legislature says, if somebody's convicted of murder, 20 years. I prefer, let's take a close look at all the facts.
Yeah. I agree, but so sometimes you just get stuck in these places where you might have to take a plea. And I know, I'm going to guess there's going to be a bunch of watchers who are going to say, no, that's wrong, and we should just fight it the whole way through. And I think in theory, that works great until you're the one looking at doing the 20.
We always have to remember something else, another variable here, which is who's on your jury.
A random group of people from your community.
It's not going to be people watching your videos.
Right. Very, very rare. They're going to get plucked out by the DA and dumped.
It's going to be a group of people. I mean, you hope if jury selection has been done properly, then the people who hate guns and say, I don't think anybody should have a gun, we got those people off the jury.
Yep.
But usually the people who come in and say, I'm a life member of the NRA, I watch John Corria's videos every day, they're gone.
So they're going to get bounced too.
So just, you might not volunteer that if you're not a hazard.
Yeah, so,
just saying. I've had great people on the jury. I wish they just shut up already.
Right.
But they keep talking. So, but normally, now you're left with people in the middle. And now you're looking at these people and you're wondering, did they vote for Hillary Clinton? Is this somebody who thinks all guns should be banned? Is this somebody who likes guns? That's who's going to be on your jury. And you also maybe don't get to pick your community. What if you get into this problem and you're in a community that is very anti-gun?
You could be a Texan, but you could be in Austin, Texas, a very liberal enclave in Texas.
There you go.
And what now?
There are many reasons for the wisdom of avoid the problem in the first place.
We're saying it again, guys. Well, I thought we were going to talk about the trial, but we haven't even got to the trial yet. Now we were talking just about this idea of now the negotiation, and maybe we would take a plea bargain. And this gives me great heart because I think sometimes we go, wow, why would you take a bad plea? Well, sometimes the alternative is so bad that you just, I gonna dance with the devil I know instead of the devil I don't.
Risk management.
Risk management is a definite thing. And of course, all this takes time in your attorney's office. All this takes back and forth with the prosecuting attorney, and all that costs money. And, you're talking about hundreds of dollars an hour to do this stuff. So you're still paying it out of your pension fund, friends. Well, next time I tell you we are going to get to the trial, because when we finally said no, or the prosecuting attorney said, nope, you don't get a deal. You get a jury trial and you're going to get the hammer. That's what comes next. Mark, appreciate the knowledge, man.
Thanks for having me.